Good morning. Are you Veronica Randall?
It's Your Honor.
And Ms. Randall was previously in court in cause numbers 25 DCCR 0246 and 0247. Entered pleas of guilty to theft of property with previous convictions, a state jail felony. Also entered pleas of true to prior convictions, which enhanced this to I believe, second-degree felony for punishment purposes. The agreement was for a cap of 6 years in prison. I've received and reviewed that pre-sentence report. Have you all both had an opportunity to review that report?
Yeah, Sean.
Yes, sir. Are there any additions or corrections to the report?
All good? What you read? All accurate? There we go. No additions.
Judge, I don't have any additions or corrections. I would just state if it's the appropriate time for the court. When I look at it, I have some empathy for Ms. Randall based on the comments that she made. But how much can we take her out of her word with her criminal history? The court will recall you previously rejected 4 years in this case. I'll defer to whatever you think appropriate. Yeah, Judge.
I also have taken judicial notice of the jail incident reports. You both should have copies of those. Have you both had an opportunity to review those as well?
Yes, sir.
Yeah, Sean.
All right, Mr. Vasquez, you may proceed with argument.
Your Honor, I know Ms. Randall's had probation a couple of times in the past, and it didn't work out for her. But I'm arguing for anything that does not involve incarceration. Ask the court to just grant her probation with every condition, and that the court thinks best would help her to quit offending. And in lieu of that, in the alternative, Your Honor, I'd ask for something less than the 6 years, if she's willing to.
Anything else, Ms. Malfini?
Judge, I don't have any additional comments. I would just state that our agreement initially was to dismiss the new case because she already has the sequence felony priors that would enhance anything further. But if the court disagrees with that, we can visit about it after the sentence.
So, Ms. Randall, I made some notations on this pre-sentence report, some issues and maybe some mental health issues that have contributed some issues in the past. However, there's nothing in here that makes me believe that any condition you may have is what requires or makes you go out and do what you've done. Literally since 1981. Your first theft that I have here was from an arrest from 1981. Then I have one after another misdemeanor thefts through 2018. Then we've got, starting in 1986, a robbery and a theft. And then we've got 13 felonies since then. These are your 14th, 15th, and I guess 16th felonies. At some point, you got to figure it out. There's opportunities when you are not incarcerated and not on probation to get the help that you need if that's what you think is the problem. I think the problem is you just like to go steal or rob, because I mean, we've got robbery, aggravated robbery, another robbery. Anyway, so at this time, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find that you also entered your pleas of true to those prior convictions freely and voluntarily. In cause number 25, DCCR 0246, find sufficient evidence to find you guilty, and at this time find you guilty of theft of property with previous convictions. Find the other previous convictions true, sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 25, DCCR 0247, I'm also going to find sufficient evidence to find you guilty, find those prior convictions true, sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. In cause number 26, DCCR 0312, find sufficient evidence to find you guilty, and find all those counts true. And in that case, sentence you in accordance with your agreement to a term of 20 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to run those prior counts true. And at this time, find you guilty of unlawful possession of a firearm by a felon. Sentence you in accordance with your agreement to a term of 35 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence. Find sufficient evidence to find you guilty, and at this time find you guilty of abandoning or endangering a child. Find those prior convictions true. Sentence you in accordance with your agreement to a term of 35 years in the institutional division of the Texas, you the right to receive. In cause number 26, DCCR 0315, find sufficient evidence to find you guilty and find all the prior convictions that you pled true to true. And at this time, find you guilty of theft of a firearm. Find those convictions true. Sentence you in accordance with your agreement to a term of 20 years in the institutional division of the Texas Department of the right to receive. And then in cause number 26, DCCR 0316, find sufficient evidence to find you guilty, and at this time find you guilty of aggravated division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. All of these cases will run concurrently, which means together at the same. Your written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts. You can talk with Mr. Vasquez. All right, ma'am, you can go back with the bailiff. Are you Michaelan Jones?
Oh, Your Honor.
Mr. Jones, in cause number 22-39715, I have a motion to revoke your,
I'm sorry, just roll.
I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation July 18th of 2022 for the, and it looks like the agreement is for you to go forward on counts 2, 3, and 4 in that motion. Count 2 alleges that you violated your probation by committing the offense of parish of Point Coupe in Louisiana. And is that true or not true?
Yeah, no.
True or not true? Thank you. 23, also in the parish of Point Coupe, Louisiana. And is that true or not true?
True.
And then count 4 alleges that you committed the offense of possession of a Schedule I drug on May 7th, or not true?
True.
Did you enter your pleas of true to counts 2, 3, and 4 freely and voluntarily?
Yeah, no.
And did you plead true to those counts because they're actually true? This is exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yeah, no.
Do you fully understand them?
Yeah, no.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 2, 3, and 4 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, and at this time find you guilty of possession of a controlled substance. Sentence you in accordance with your agreement to a term of 21 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
Judge, if I may, the motion was filed in June of 2023 based on offenses that happened in May of 2023. He's been in Louisiana custody since those offense dates of May of 2023. However, our hold for this motion to revoke didn't get placed on him until October 7th of 2024.
And Judge, Mr. Rojas, I'm sorry to interrupt, Mr. Rojas, and I have conferred, the state is not opposed to the court giving the defendant the credit for the time he's been in jail while this case is pending. You may recall, I've researched the issue. I actually briefed it and I gave the court that authority.
You did.
I think you have that authority if you choose to award him that credit.
Okay, so what I'm thinking I would do, I'm not going to go back to the offense date. I think the cleaner way to do it is to go to the date of the motion,
Okay.
which is just a month or so
Right.
or less. But I think that at least for our purposes, if somebody's looking at it, they'll see motion was filed on that date, warrant was issued, but there wasn't a hold place for some reason.
Correct.
And so I'm going to allow credit from June 7th of 2023. In whatever time that adds up to, I will, we'll get that done. Okay?
Thank you, Judge.
All right, so Mr. Jones, I am handing you the trial court certification. Well, two things. One, showing that this was an agreement, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. All right, good luck to you, sir, and thank you, probation.
What started as another routine sentencing hearing quickly turned into a brutal reminder that some defendants run out of chances long before they realize it. Veronica Randall stood before Judge Boyd with a criminal history stretching back over 40 years. Thefts, robberies, aggravated robbery, and now multiple new felony cases stacked on top of each other. The courtroom grew heavier with every charge read aloud. The judge reviewed everything: decades of arrests, repeated probation opportunities, prison sentences, and the same pattern repeating again and again. Defense attorneys argued for mercy, mental health treatment, and alternatives to prison, but the court had heard it before. Then came the moment that changed everything. Judge Boyd looked directly at Randall and made it painfully clear. This wasn't about one mistake anymore. This was about a lifetime of chances that never stopped ending the same way. One by one, the sentences came down. 6 years, 20 years, 35 years, another 35 years. Even though the sentences would run together, the message hit hard. The system had finally stopped believing rehabilitation was enough. Then another defendant appeared, Michael Jones, admitting to fleeing police, carrying a weapon, and possessing drugs while already on deferred probation. But in a rare moment of fairness, the judge agreed to credit him for years already spent locked up in another state. And that contrast made the courtroom feel even more intense. Because in court, every decision becomes a line between mercy and consequence. Some people walk away with another